This is Bloomberg Law with June Grasso from Bloomberg Radio.
The prosecution's case against Donald Trump in his hush money trial has been building up to today. The testimony of its star witness, Michael Cohen, Trump's one-time lawyer and fixer, and now the main witness against him. Trump is accused of falsifying business records to cover up hush money payments that Cohen made as part of efforts to buy and bury stories that might hurt the former president's 2016 campaign. In his testimony today, Cohen connected his former boss to the payoff to keep adult film actress Stormy Daniels from going public about their alleged dalliance to save his presidential campaign. Joining me is Bloomberg legal reporter David Voreacos, who's covering the trial. David, everyone has seen interviews with Michael Cohen where he's very energetic and very vocal about his dislike for Trump. What was he like on the stand today?
Michael Cohen was very subdued and factual today. He displayed very little emotion. He answered questions from the prosecutor, Susan Hoffinger, succinctly and didn't elaborate. And he referred repeatedly to Donald Trump as Mr. Trump. He didn't insult him. He didn't belittle him. And he essentially took jurors back in time to 2015 and 2016 when he almost seemed to be in awe of Trump and, spoken of him and behaved toward him glowingly, and that he made clear to jurors that he wanted to do anything he could to protect Trump and to protect his presidential campaign.
Before he got to the Stormy Daniels payment, how did the prosecution build up to that?
They went through his career history, how he had worked for the Trump organization for 10 years. He'd taken care of a number of, messy disputes involving Trump, that he had won Trump's confidence, and that he also made clear to Trump that he was willing and able to do anything necessary to help out Trump. And that included dealing with media people and anyone that sought to harm Trump in any way. Cohen made clear that he was willing to bully and badger people so that Trump would get his way. He was willing to try to reduce bills and either persuade reporters to soften or kill stories. He also testified about a key meeting at the heart of this case, which was in August 2015. Trump met with David Pecker, who was the CEO of the company that owned the National Enquirer, and the three of them sat down and made this agreement that prosecutors say was the corrupt agreement in which the National Enquirer and David Pecker would publish flattering stories about Trump, would attack his rivals, and would also, that the National Enquirer would look out for any negative stories about Trump involving women and would then alert Cohen. That's in fact what happened, and that Pecker or his editor at the National Enquirer, Dylan Howard, told Michael Cohen about potentially unflattering stories about Trump and women.
At one point, they played a tape that he had made of a conversation he had with Trump. Tell us about that.
Right. That conversation was in early September 2016, so a few months before the election. There was a former Playboy playmate, Karen McDougal, who had a story to sell that she had had an affair with Trump for nearly a year. And Trump and Cohen did not want that story to get out. She had been in negotiations with ABC to tell that story publicly. And she was also in negotiations with American Media Inc., which owned the National Enquirer, to sell that story to them through a so-called catch and kill agreement in which the Enquirer would buy the story, or AMI would buy the story and not run it, and they would give her a number of columns. The purpose of the deal, we've learned through this trial, was to protect the campaign. And so this call took place in early September of 2016 because, according to Cohen, David Pecker was concerned that Donald Trump was not going to repay him the $150,000. And so Trump spoke to Cohen, who was secretly recording him on his iPhone, and Trump understood the terms of the deal and mentioned 150, which Cohen explained was Trump acknowledging that this was the deal with Karen McDougal. They would pay her $150,000, and Cohen would use a shell company to handle the deal.
I wonder if that tape cuts both ways, because it seems like it's Cohen leading. Trump says cash, and Cohen goes, no, I have this all handled. I've got the details, basically. I mean, does that cut against the prosecution in a certain way? Because, Cohen's taking the ball and running with it.
It's possible to read it that way. It's not completely explicit, so there's certainly room on cross-examination to craft an alternative narrative, as there is on a number of other aspects of Cohen's testimony. For instance, in the agreements with Stormy Daniels, they used pseudonyms, including David Dennison and Peggy Peterson, and when it came time to sign a side agreement that spelled out who the actual identities of Dennison and Peterson were, Trump and Stormy Daniels, Trump never signed it. And in fact, later in that document, Cohen signed DD's initials, and he said that he was doing that on behalf of Trump. But there's certainly room for vigorous cross-examination on that front by Trump's lawyers when it begins probably tomorrow.
Tell us how Michael Cohen explained the Stormy Daniels payoff and whether he had any document to back him up.
The Stormy Daniels payoff came in late October of 2016, right before the election, and it came after the release in early October 2016 of a very damaging video known as the Access Hollywood tape, in which Trump spoke about, women and the different ways he could behave with women. And it was seemingly a devastating tape, and the campaign was quite concerned about its impact on women voters. So when Stormy Daniels came forward, they were anxious to settle this case, and the jury heard a lot about the negotiations to settle the Stormy Daniels matter, and that Trump told Cohen that he wanted it settled. Cohen, however, could not get Trump to pay it himself, and Pecker refused to pay it. So Cohen took out a home equity line of credit at First Republic Bank and paid it with his own money. So now this gets to the heart of the case. The case is about 34 felony counts alleging that the Trump Organization and Donald Trump specifically falsified business records to cover up the reimbursement to Michael Cohen for making the Stormy Daniels payment.
Tell us about the notes on the $130,000 wire and how that plays in here.
There's a very powerful document in which Alan Weisselberg, who had been the CFO of the Trump Organization, made handwritten notes on a bank statement that Cohen brought to him from First Republic Bank, and that statement showed that Cohen had paid $130,000 to Stormy Daniels' lawyer. And so what the statement shows is that in his own writing, Weisselberg wrote down that Cohen would be paid $130,000 plus $50,000 that was going to another tech firm that Cohen claims he paid. And so that's $180,000. And according to Weisselberg's notes, it would be grossed up, which meant they would double it so that Cohen could pay taxes. And then they added a $60,000 bonus for $420,000 then it was divided by 12, which gets you to $35,000 a month, which was the reimbursement amount to Michael Cohen. What Cohen testified was that he did no legal work and there was no legal retainer outlining work. It was really only a payment for the reimbursement, which makes it non-taxable. And so he says that calling these payments under a retainer was a fraud, essentially, and that was a sham agreement. And so that really gets to the heart of the case, because what makes the business records false in the eyes of the government is that Cohen was not being paid income under a retainer. He was being reimbursed.
The prosecution has to show that Trump knew about this, right, and the reason for it. Is that as close as they've come so far?
We've previously seen this exhibit with Weisselberg's handwritten notes, but Cohen testified that Trump knew that this was a reimbursement. And so that's the closest we've gotten to Trump's state of mind and intent here.
Cohen's testimony will continue tomorrow, and it's expected, because it's moving so quickly, that cross-examination will start tomorrow as well. Thanks so much, David. That's Bloomberg legal reporter David Voreacos. Coming up, another trial just starting across the street from the Trump trial. It's one that Wall Street will be watching. You're listening to Bloomberg. At the federal courthouse in Lower Manhattan, just across from the courthouse where Donald Trump's hush money trial is playing out, is what promises to be one of the most closely watched Wall Street trials. Bill Huang amassed a fortune of $36 billion in near total secrecy through his family office known as Archegos Capital Management. But it was a very public collapse when Archegos suddenly melted down in March 2021, all but erasing Huang's fortune. The collapse also cost the firm's lenders $10 billion and contributed to the downfall of Credit Suisse. Here's Manhattan U.S. Attorney Damian Williams describing what he called a massive fraud and market manipulation scheme.
We allege that the defendants and their co-conspirators lied to banks to obtain billions of dollars that they then used to inflate the stock price of a number of publicly traded companies. The lies fed the inflation, and the inflation fed more lies. Round and round it went. But last year, the music stopped. The bubble burst, the prices dropped, and when they did, billions of dollars nearly evaporated overnight.
The trial began in earnest today with opening statements from the prosecution and defense. Joining me is securities law expert James Park, a professor at UCLA Law School. Jim, will you explain what the prosecutors are accusing Huang of doing?
Well, there are a couple of major allegations. The first is this is a market manipulation case. They're accusing Huang and Archegos of purchasing stock in order to inflate the price beyond natural market forces, and that violates federal securities law. Secondly, they're alleging that he and his subordinates lied to banks in order to get the funds to speculate in the stocks. And so the first allegation, I think, is probably the more difficult one for the prosecution. It's a little bit unclear as to how we define market manipulation. There have not been very many prosecutions of manipulation involving what we call open market purchases of stock, where you're just buying securities in the marketplace. The second set of allegations, though, I think is more straightforward, more established, and it could be just a simple federal wire fraud. So there are really two sets of allegations here.
Huang's lawyers have described the prosecution as the most aggressive open market manipulation case ever. Do you agree with that?
It certainly is the biggest that I have heard of. And, any open market manipulation case is somewhat novel because they are not brought very frequently. And the law is unclear. And I think that there, is certainly going to be sort of a challenge, I think, in terms of whether or not the facts will support a violation of market manipulation. And I think that, this set of facts that was unprecedented, and I think that is part of the novelty of the case, is that at one point in time, he had a position of $160 billion in a number of these publicly traded securities. So it is certainly the largest market manipulation case involving open market purchases of stocks that I am aware of, and that makes it somewhat unique. As to whether or not it is something that is an abuse of federal authority, I think there has been at least one decision in the SEC civil case that did find there were sufficient allegations to support a manipulation claim. So certainly there is some support for the federal prosecutor's position.
I've read that looking back, his strategy seems like market suicide. In the opening statements, the prosecution said that Huang wanted more money, more success, more power, that he wanted to be a Wall Street legend. But the judge has said he was bewildered by Huang's strategy of simply buying more and more shares. At a hearing, Judge Hellerstein said, "What did he want? What did he want to achieve? Being a big shot, I suppose that's possible, but it doesn't seem to me that was his aim."
The prosecutor said he wanted to be a Wall Street legend. That certainly is a possibility. Another explanation is that he basically dug a hole for himself. He got too aggressive. He established a really large position that left him vulnerable if the market changed. And so he did everything he could in order to get himself out of significant losses. And so it may be partly that he wanted to be this legend. He was not content being a billionaire that was fairly obscure. But, the other motivation, I think, might have been just desperation, and that he was in trouble and he wanted to do everything he could in order to make sure that he didn't lose a lot of money on these various trades. And, it would have been humiliating. And it was humiliating when he lost billions of dollars in money that was borrowed and his own money in these trades. So I think there are a number of ways you could look at what his motivation might have been. Now, in terms of whether or not this is completely irrational, I think that that'll be a critical part of the prosecution's case. I think one of the things they may do is they may say, well, here were the things that he was planning to do to earn a profit on this position, that there's a way he could have gotten out of it with some profits. And I expect that various cooperating witnesses will give us a little bit more insight into what the strategy was. So there was a motivation asserted by the prosecution. In addition, I think we're going to learn more facts at trial as to what the motivation might have been.
Some of what the defense lawyers say is that it was a family office and they weren't required to disclose positions. Also, though I don't know how much the judge is going to allow this, that the banks were sophisticated lenders who were doing their own research.
They are sophisticated lenders, but you can commit fraud against sophisticated lenders. And we're going to probably hear some testimony from these banks as to, what they expected and what type of information they were looking for and how the lies affected what they would have done. Would they have, pooled the loan? And is there some precedent for doing so? Did he prevent them from really responding and preventing what actually happened? I think we're going to get some testimony from these fairly sophisticated lenders. But I think he has a point, right? The defense does have a point that, these are banks that should have done more due diligence. They should have taken care of themselves, and they were quite capable of doing so. But what the banks will say is that we didn't expect we'd be lied to. We didn't expect that we would be lied to by this individual investor.
Where does it fit in that this was a family office?
Family office basically manages only the funds of a particular wealthy individual. That's what a family office is. It doesn't take in money from outside investors. And because it is a family office, you could argue that there's less need for regulation because the only person who would be harmed from losses would be Mr. Huang himself and his family. They're the only ones who have money invested in the fund, and therefore we don't really need disclosure requirements, registration requirements with respect to a fund like that. But as we can see, though, that a fund of this size, even though it's a family fund, can cause havoc on other people and third parties, such as the banks, and more importantly, the general market as a whole. Just the instability of unwinding these positions affected a lot of individual investors and reduced trust in the marketplace. And so there are additional consequences for family offices of this size that may support some additional regulation.
I've been reading a Bloomberg news story which said that one of the defenses will be a time-honored Wall Street argument that he's not responsible for the other side's losses. Has that worked in these kinds of cases?
I think that there are two types of losses that we might think about here. One is that, individual investors might have lost money because the stock was inflated and they came in and bought at inflated prices. If there was, in fact, market manipulation, though, the federal securities laws are in place in order to provide remedies for this type of manipulation. That was one of the core reasons why federal securities laws were passed, because of the perception that corporate insiders, market insiders, were basically manipulating markets for their own gain and basically defrauding individual investors who could not trust stock markets because of this manipulative activity. So the federal securities laws would be a fairly good rebuttal to that type of losses. The other type of losses are with respect to the losses of the banks that provided the funding, the money that was used to invest in these stocks. And even there, the federal securities laws do apply. And there are some technical issues, I guess, in terms of the types of misrepresentations that were made that will have to be worked out. But at least in theory, if you are lying about loans that are being used to purchase securities, then that would also be covered by the federal securities laws. And those laws are in place for a reason, and they say that, we don't have a system where the buyer has to beware. We can trust securities markets, and that's why in certain circumstances, investor losses are recoverable from those who manipulate stock markets, who lie to investors and other parties. So I think that the federal securities laws are a powerful rejoinder to the argument that investors should simply bear all of their losses.
So the biggest challenge you mentioned at trial will be the two cooperating witnesses. So far we saw that in the opening statement, the defense attorney called the former head of risk management, Scott Becker, manipulative and a very, very convincing liar. So it seems like the defense is going to attack the star witnesses in part by saying they're lying because they wanted to get out of the charges and get a plea deal, which we've heard over and over and over again whenever there's a cooperating witness, basically.
The standard defense in these types of cases. If you have a cooperating witness who is testifying against you, that's the job of the defense attorney to undermine their credibility. And that's the reason why we have trials. The reason we have a jury look at this evidence and hear this testimony is that a group of 12 ordinary individuals may be the best way of assessing whether or not somebody is lying or telling the truth. And this is the sort of argument that is made every single day in federal courts throughout America, whether it's a drug possession case or a drug dealing case or something more of a financially sophisticated crime. These federal cases depend upon cooperating witnesses. It's the job of the federal prosecutor to make sure they believe the cooperating witness, and they have to try to independently verify what that witness is saying. And, hopefully they did a good job in this case. And that's up for the jury to decide that whether they believe the cooperating witness or not. More recently, this is what the FTX trial also hinged upon. Sam Bankman-Fried was charged with various counts of wire fraud and securities fraud. And the reason he was convicted was because his top lieutenants testified against him, and there were attempts to try to reduce their credibility. So this is what these trials ultimately come down to. Who do you believe? Do you believe the cooperating witnesses, or do you believe the defendant? And the other interesting question I think that will come up is, will this defendant actually testify in his own defense?
Hold that thought, Jim. Coming up, I'll continue this conversation with UCLA law professor James Park, and we'll discuss the impediments to Bill Huang taking the stand. I'm June Grasso, and you're listening to Bloomberg. Trial began today for the founder of a hedge fund that cost leading global investment banks and brokerages billions of dollars when it collapsed. In opening statements, the prosecution portrayed Bill Huang, the founder of Archegos Capital Management, as a greedy man hoping to become a Wall Street legend, while Huang's lawyers said he was an honest investor, fearless about losing money in stocks he believed in. Two of the main prosecution witnesses are insiders who reached plea deals with the prosecution. I've been talking to Professor James Park of UCLA Law School. And what are some of the reasons why you think he might want to take the stand in his own defense?
I think that after the cooperating witnesses testify, that there will be a lot of explaining to do, right? If he really wants to come and defend himself, I think that it all comes down to his state of mind. And so the only way the jury can really understand his state of mind is if he comes and testifies and basically argues that, they were wrong, they're lying, and this is the reason why. Now, if he does testify, though, that puts him at great risk because, about a decade ago in one of his prior hedge funds, he had to settle a case that the SEC brought and the Department of Justice brought against him for insider trading. And then also in the SEC case, there were allegations of similar types of market manipulation, where he was ordering subordinates to enter into losing trades in order to create the impression that his position was a profitable one. And that would be very bad, I think, for his defense if the jury learns that he has been charged with similar types of misconduct in the past. And that's why he's running a family office, is because he had to settle with the SEC and the Department of Justice. And that's why he's not able to really manage outside funds by investors.
His defense attorney in opening statements said that the prosecution's argument that he risked everything because he wanted more money, more success, more power. He said it doesn't make sense because he didn't live the life of a billionaire. And much has been made of his sort of low-key, average lifestyle.
I'm not sure. Is it a persuasive argument that he was not spending the money? I think the thing that happens, when life is built around investing and trading is that it's kind of a game in a sense, and that this is what he does, and he has done it very, very well, and he wants to win, right? And regardless of whether he spends the money, I think he gets some sense of pride and sense of fulfillment out of showing that he can beat the stock market. And, Warren Buffett, for example, is somebody who lives very modestly, but spent his whole life investing in companies. And he, I think the reason why he does it is because he enjoys it and he gets some self-worth out of being somebody who can outperform the marketplace. And that's what Bill Huang might have been trying to do.
So the jury is this typical cross-section of New Yorkers. And jury candidates who had Wall Street ties were excused. So few have financial backgrounds. The judge has said the trial will be Finance 101 for many of them. He said, if you sit through 8 weeks of trial, you'll be able to go out and manipulate the market. I mean, is that a downside for the prosecution, not having people who would understand these sophisticated transactions?
It poses a challenge. It poses a challenge to explain things like a total return swap and exactly what sorts of practices were happening at this particular fund. There's always a risk the jury will get confused. And so the prosecutors are going to really have to go step by step and explain just exactly what the fund was doing. And, that is going to take some time. There's always the risk that the jury will tune out and not really understand all of the details. On the other hand, I think there are some aspects of the case that should be fairly simple to understand, where, I've borrowed money essentially from this bank and they want to essentially know what's going on, and I don't tell them the truth, right? I think that's a very simple set of facts that most ordinary jurors will be able to understand. I think the more challenging kind of part of the case is the market manipulation case and trying to distinguish, what exactly did he do wrong in relation to normal practices on Wall Street, normal practices that an aggressive trader might essentially use in order to beat the market. And so there are, questions about, is it manipulative to phone in a lot of orders at the end of the day when there's not a lot of trading? Is that something that we can say is deceptive in intent, or is it simply industry practice? And so I think the jury will need some information in order to make that determination. And I think it'll be difficult. I think it'll be difficult for prosecutors to clearly explain, why this sort of trading crosses a line into manipulation that violates federal securities law and gives enough facts for the jury to distinguish this type of manipulative trading from what would be normal, aggressive, but non-manipulative tactics that are used by hedge funds and other investors.
So he's, Jim, being tried alongside the former chief financial officer, Patrick Halligan. Halligan's attorneys seem to be trying to distinguish them in opening statements. Do you think that their cases rise or fall together?
There could be differences in terms of the defenses. I think what Huang would say is that, my subordinates were doing all this stuff that I was not completely aware of. I didn't realize all of the specifics of what was being said to the banks. That could be his defense. I'm fairly confident that that's the sort of thing that he's going to try to argue, is that, my subordinates, they went overboard, right? They lied and I didn't know it. I didn't actually speak to the banks. My subordinates did. The CFO may have different interests than Huang, and he may point the finger back at Huang and say, well, actually, no, he was the one telling me to basically lie. And so there could be different interests here in these defenses and different positions that they may end up taking in the trial.
This case is one of several that the U.S. Attorney in the Southern District, Damian Williams, brought that alleges wrongdoing by powerful investors amid the market swings during the pandemic. Do some of these cases just go, too far? It's like, is the effort too broad?
I'm not really aware of a particular case that has gone too far. I think that they are challenging cases, though. I will say that, cases like this are pretty challenging in terms of establishing fraudulent intent. But, I think it is conduct, though, that has to be looked at, because there was a period of market turmoil, and you could argue that there are certain individuals who tried to exploit that and take advantage of it. I think what Huang would say, though, in response, is that I really believed that the market was going to come back. And so I really just made a big bet that the market overreacted to the effects of the pandemic. And so I really invested a lot in making that bet, and it just didn't work out. And, why should I be criminally charged and serve prison time for making a mistake when I really believed that these stocks would go up in value? And I think that's the type of defense that we heard a little bit in the defense's opening argument, that he had conviction about the value of the stocks. He sincerely believed that they were good investments, and so he was not deceiving anyone.
It promises to be a very interesting trial. Thanks so much, Jim, for giving us this preview of it. That's Professor James Park of UCLA Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.